Lawyers who read wills to families. What is the most interesting, bizarre, offensive, surprising thing you have had to read out loud? There is no such activity as the reading of the will in an estate settlement. My father passed away. I handled his affairs. It was sad. I had a copy of his will which was in the executor's packet he put together 25 years earlier when he paid a lawyer to write the will and file it. I read the will then, in his bedroom. Then I called his lawyer to file it for probate. We went through a lot of estate valuation meetings to determine how best to document his assets. I did a lot more accounting than I thought I would. Either I calculated depreciation or I paid his lawyer to do it. So it was better to do it myself. So what happens when a person passes away? Does the lawyer contact individual people and tell them what they got? I believe if an executor, who doesn't have to be an attorney, has been appointed, the executor does that. Maybe a better question is asking estate lawyers what's the weirdest thing they've drafted. I'm also curious what the answers would be. I feel like this is also a good time to mention that not long after someone dies, some lawyers will send out predatory letters to immediate family saying the deceased had numerous debts that still need to be paid and you need to hire them so you don't become liable. Please throw those directly in the trash. We just had that happen when my mom died. Luckily my dad was in charge of finances and knew it was BS. I'm sure an estate lawyer will chime in, even if the premise is wrong. They aren't going to be too confused with the intent of the question. I'm thinking more along the lines of that woman who left her millions of dollars entirely to her dog. Or if someone wanted to bequeath their collection of toenail clippings to their favorite niece. IDK. Weird shit. I can't find it, but I know I've got it saved somewhere. There was a case my supervisor solicitor told me about during my internship. There was a woman from a very conservative family who had a live-in female companion. She had quite a bit of money from a previous marriage and was unfortunately very unwell. Matter of when, not if. She could not leave it to her companion because same-sex partnerships weren't recognized in either marriage nor de facto status at the time. You could however leave money for the carer of a pet, including living expenses for the duration of the pet's lifetime. The family agreed not to contest the will on this because how long could an animal live? It was better than people finding out the scandalous truth. There were even documents showing where they felt they were being very generous about the whole thing. Remember how she was rich? In a goddamn gangster move she imported a specific breed of tortoise which can live well past 100 and needs minimal care. The stipend for the tortoise kept her partner quite well looked after for the remainder of her years. Family couldn't contest it because they'd shoot any chance of money in the far future after agreeing to terms. Snuffed loudly at the end. Not ashamed. Since most people can read, lawyers don't have to read wills out loud. I know reading of the will isn't a real thing, but having read my husband's parents' wills, I think sometimes this could be useful. My husband and his siblings all have a copy. They all have read it and understood it differently. Having read it myself, none of them have a correct understanding of what it says. They all get sweet nothing. The estate goes into a trust to provide for medical care of the special needs sibling. In the event that he dies, anything left will go to the living siblings or their kids. Was a wills and estates lawyer. The best thing you can do is tell your nominated persons while you're still alive. I'm fairly young, but because of my profession, I've had this conversation with certain members of family, my partner and friends whom I've put into my will. I've given them personal documentation of what I've said, confirmed that they have it, and have included copies and confirmations with my own docs. Done. I don't read wills, but here are some fun ones. 1. Leaving money to cats/dogs/parrots. 2. Expressly leaving nothing to one child. 3. Leaving things to museums and galleries who do not want them. No one wants your crappy paintings. 4. Leaving things in joint ownership of people who hate each other. I used to work at a museum and #3 is a big one. Museums will try to get long-time donors to leave money in their wills or to will some important paintings from their collections to the museum. But sometimes people will insist on leaving their whole collection or including a bunch of art that they think is important but actually isn't. And then museums have to deal with storing a ton of shitty paintings your sister did of a horse or whatever until enough time has passed that they can get rid of them. Most museums have worked on changing their rules for collecting, etc. to prevent this from happening now, but the place I worked at had a massive backlog of weird donated art from previous decades that I would have to drive to auctions to get rid of. Not a lawyer, but a pre-law school friend said he wants to have 2 kids, and when he dies he will be cremated, and the ash will be used to make a grabber boat. Then he will give the grabber boat to one of the kids and they will have to figure out if that makes them the favorite. Lawyers don't read wills anymore. They may have when the majority of the population was illiterate, but anymore they will just give it to the relevant people to read. Executors, beneficiaries, etc. Depending on policies/laws that are relevant. Better question would be asking the strangest thing seen in a will, or drafted as part of a will. I understand, but I just wanted to use it as a catch-all one. Plus when I made it, I was pretty much half asleep. You admit you have tried this very post before and it didn't take off, so don't pretend you were of a level of intelligence to know this wasn't a thing. The reading of the will was pretty much invented by and for soap operas, and doesn't actually exist. That's not true. Reading was done in times where lots of people were illiterate so everyone could understand it, and although it's not necessary it still could be done now, if they wanna do it. I was a wills lawyer for a couple years. Love the subject. You're spot on. The reading of the will did exist because of a lack of literacy and authoritative pedigree/access some 200 years ago. However, a change in literacy rates and how wills are handled, at least here in Ors, have rendered a will reading redundant. You can request it from a lawyer, but as under law they can't really get paid for it unless it's particularly onerous for some reason. It's likely they'll try and get you to nominate someone you know to do it instead of them. Reading out the will only happens in the movies. Otherwise, you get the will and you read it. Then you find the section which concerns you. End of story. Oh man, I have a story. Obligatory, not a lawyer. My great grandfather was a worker on a man's farm for about 20 or so years. Never missed a day and always stayed late. The farm owner's son was arrogant, spoiled at the thought of maid life, and treated the workers like garbage. When the owner died, my great grandfather was called to the will reading, which he thought was strange, but of course he went. The farmer's son sat at the table all smug at his inheritance, only to have the lawyer read that my great granddad had actually inherited the farm, all equipment, and any estate money. I wish that portable cameras were popular back then, so I could've seen his face. But the lawyer's family are still our lawyers for the estate today, and they say he really enjoyed reading that part, lol. Yeah, reading the will isn't really a thing here either. You just call the notary, they check the national register, and the family comes in for a meeting to discuss legal matters. The saddest one for me was the longest living parent passing away, changing their last will on their deathbed. Literally a few days before their death, they disowned one of their children because said child was gay and they didn't approve of their life choice. It completely destroyed the children left behind and their family relationship. They were thick as thieves and this completely destroyed their bond. Broken beyond repair. I tried to mediate as best I could, but it got so ugly. Please, for the love of God, think about what you leave behind. Because said parent is no more yet is solely responsible for wrecking the bond between their children. This reminds me a little of when my grandparents died. My nan passed first, and at that time their will said everything went to my granddad until he passed, and then all the estate and money was divided between my dad and his sister, and my nan's jewelry went to me and my female cousins. My granddad passed about 2 years later, but had hired a lady to clean for him in this time, and we didn't know he had changed the will, so she got a percentage of the money and all the jewelry. We found out she had been manipulating him, but my dad and aunt were gutted. Not about the money or anything, but more about how cold my granddad had been to them, and basically took preference of the cleaner, who never actually cleaned. Closed bracket comma, and went against my nan's wishes. Man, that is rough. A few more. Person named their best friend executor, and left everything to her family. Family made the life of the executor so hard. After a year of not getting anywhere, the executor asked my office to step in and take over. Person organizing their own funeral to the most minuscule details. Who only gets a slice of cake. Who also gets a sandwich. Which people get to go in a follow car and which not. Weirdest thing was, This person was relatively young, a fake perfectly healthy, so nowhere near actually dying, yet so preoccupied with their own death. That one really weirded me out. Coolest cases I've had were those who didn't make a last will but really should have, since they had no direct next of kin. So you wind up with second, third, fourth cousins and so forth. Currently trying to settle a will with over 100 heirs. Still nowhere near completion, because 2 family branches moved abroad post. www. I can't find them. You should see the family tree. I love sifting through city records and creating order in the chaos. At least you're doing what you love. Normally they are not read out. The court handling the proceedings just sends out letters to any relatives they have on file, or know the whereabouts of because they are on file at the registrar's office. In case of really wealthy individuals, as in, have their own lawyer or lawyers only working for them personally, they might have made special arrangements for handling the proceedings and for putting extra effort into finding prospective heirs during normal court proceedings. Not too much energy is wasted on that if they can't find any, and nobody comes forward. The inheritance just goes to the state. Also, there's rules in place that make it impossible to demand anything too exotic, outrageous or drastic. For example, it's not possible to completely disinherit somebody unless it's the gravest of circumstances, like an heir also being the killer of the deceased, etc. In normal cases, family fights, old grudges against Aunt Hilda, etc., you can only freely assign half of your wealth. The other half will get divided up by the inheritance formula as defined by law. Spouse gets everything, unless there's children. Then they get half and the spouse gets half, etc. Meaning, if you declare all of your wealth to be given to your pet monkey Pogo, only half will actually go to him, and 1/4 will go to your spouse, half of the remaining half, that you can't freely divide up, and 1/8 will go to each of your 2 kids, splitting the other half of the lawful half. So, not a lawyer, but this reminded me of some historical research I've been doing for a book I'm writing. The guy whose biography I'm writing has a long, complex will, and in big letters on the first page, announces that his next eldest brother, who would be expected to get everything at the time, gets a grand total of 1 shilling. I wonder what the second oldest brother did to piss off the older brother. It happens that is in the archives too. He refused to help his much richer, having inherited from their father, out of a financial hole after a business failure, or more precisely, he wanted some security if he were to help, which was refused. They didn't talk for nearly 20 years after this, until the elder brother died. The reason I'm writing a biography is the older brother is fascinating, and built what is now the world's oldest surviving yacht, 1789. Some guy left everything to Martha Cabrera. Who is Martha Cabrera? It's a movie reference. Give Knives Out a try. It's really good. Ask for them to sign for a revocable living trust, and if anyone does not agree and challenge the trust gets nothing. Many people are confused and scared when their lawyer tells them that they need to fund the trust without explaining that this just means to put the name of the trust on your bank accounts and assets into your account in living trust, and by changing the name on your bank accounts and properties and investments. For example, all bank accounts are now in the name of your name George Smith Living Trust, was a wills and estates lawyer. I think a living trust is a good option, but bear in mind 1. Your will needs to be super specific about what accounts fund the trust along with inclusions like residuals, interest payouts, etc. Because such things weren't specifically included, I have seen people argue this minuscule crap on the basis of principle. Not even the lawyers win that one, friend. We just want to go home. Close bracket. This is much easier / effective than renaming your accounts, but you'll still have to provide a shit ton of documentation to gain access anyway, so too, it's best if the nominator sorts it out while still alive with the lawyer and the bank. Usually just the one letter per institution. No real lawyers will answer this question. They are not allowed to tell about their clients or cases in the workplace at all. It's the same as HIPAA. Generalities are fine, as long as there's no identifying information. What this guy said. I plan to require my body be mummified and kept on display in the living room of one of my kids. I want to be decorated accordingly for all of the holidays. At least for Halloween they won't need to do anything. I can't wait to see the look on the lawyer's face when I tell him that. Thank you for watching. We hope you enjoyed this video. Please subscribe for more videos.